My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we are continuing our video series designed to educate and inform the public, so please subscribe to our channel. When we talk about the custody of children, of course the court is free to make decisions based on what's in the best interest of the children in order to decide should the child live with mom or dad. The court will do this in the absence of the party's ability to come up with something that the court can live with. Sometimes couples come up with a custodial arrangement that the court gives its seal of approval on. Works perfectly for them, works perfectly for the court. However, sometimes people come up with things that the court does not find workable. The court doesn't feel that it's safe for the child, that it's in the best interest of the child, and then the court has to intervene and perhaps tweak it or modify it or otherwise come up with its own arrangement. Is there a preferred custody arrangement in Michigan? Well, sort of a loaded question. Preferred by whom? You have to understand one thing. If it was up to the court, if you ask the court what its preference is, I'm sure most judges will tell you, well, my preference is to have the custody arrangement that supports the best interest of the child. And what would that be in an ideal world? Some sort of cooperative arrangement between both parents. I mean, that would clearly be the preferred arrangement. Now, is that a feasible thing? Is that something that can be done? Can it be explored? Yeah, sometimes the parties' relationship is such that a shared arrangement can work. You got to understand one thing about the courts. The courts would always prefer that the parties try to work it out so that the judge doesn't have to make that decision. Now, you might ask, what do you mean doesn't have to make the decision? What's the job of the guy who wears the black robe if not to make decisions? And that's the job he was hired to do. Well, yeah, that may be true, and that may be true of commercial things, it may be true of criminal law, it may be true of other things, but when it comes to the management of your family, a lot of the courts would rather say, look, work these things out yourselves. You're the parents. If this weren't filed before the court and somebody offered you advice, you would say, hey, none of your business. Me and my spouse will handle that. But now that there's a divorce, all of a sudden you can't handle it, you can't make that decision, well, then the judge has to make it. But he does so somewhat reluctantly. That is to say, reluctant in the sense that the court would always rather that the parties work something out. Now, what they can work out and whether or not it's preferred for them is going to depend on a lot of things. For one, how old is the child? If your child is 16 years old, a preferred arrangement might be whatever Johnny says. Why? Because he spends most of his time with his friends anyway and really cares more about them than he does about you and your spouse. So preferred for someone who has a teenager, a young adult, soon to be a standard adult, it could be very flexible. It could be something that when the child wants to spend time with me, great. The child wants to spend time with you, great. If you've got a 3-year-old, it's a whole nother story. Preferred custody arrangement could be something that exposes the child equally to both parents. That doesn't necessarily mean 1 week on, 1 week off, back and forth, because in that situation, the child really never lives anywhere. The child lives outside of a duffel bag. It's not a preferred arrangement, really. A better way might be to split the year, not necessarily 1 week on, 1 week off, but maybe this year I get all the academic year. You get all the vacations. Next year maybe we switch. Or we work out some kind of structure that makes it generally fair in terms of the time, but at the same time gives the child an opportunity to spend time with each parent in a way that's meaningful. I mean, think about your household before the divorce. The child spent some time with dad, spent some time with mom. It could be that he did homework with dad. It could be that for things about his friends and problems, he went to mom for that emotional support. Splitting it that way may be a way to have a sort of a continuity of how you used to parent. Maybe that is preferred. So my point is this. There are different preferred methods of custody. You should take into account what the course of dealing was between you and your spouse, how old the child is, whether or not you can actually work together to come to a custodial arrangement which provides continuity and stability for your child. Now, if you have any questions about that, reach out. We'll be glad to help you out.